Welcome to The Facts. I'm Rosalyn Tavanis. The Supreme Court of the United States was established in March 1789 by the First Congress. Article 3 of the Constitution establishes the composition and the court's procedures. The court consists of the Chief Justice of the United States and 8 associate justices. Each justice holds a lifetime tenure, which in my mind is an alarming thought. The court holds the utmost appeals jurisdiction over all federal law and further holds judicial review, which means it can invalidate a law violating a provision of the Constitution. Further, it can strike down presidential directives for violating either constitution or statutory law, which are laws enacted by a legislative body, administrative law, and common law. For the last 50 years, conservatives have controlled the court. It was former President Nixon who, by appointing 4 conservative judges, began the run of conservative momentum. Previously, the court was liberal. The Warren Court was the last liberal court, and it held firm from 1953 to 1969. During this time, the court expanded the force of constitutional civil liberties. Some issues ruled upon during the Warren Court were: segregation in public schools was ruled unconstitutional. Gerrymandering, which is the manipulating of voting boundaries so as to favor one particular party or class, was ruled in violation of the right to vote. A general right to privacy was created for all citizens. The role of religion in public schools was limited. The rights granted in the Bill of Rights were strengthened at the federal and state level. The right to an attorney was guaranteed for all, even if a person could not afford one. The reading of Miranda rights, one's legal rights when put under arrest, was made mandatory. These are just a few of the rulings that the liberal Warren Court had implemented to protect the rights of citizens. Since President Nixon installed 4 Supreme Court justices, the court has become a much more conservative entity, and the conservatism that is reflected in its rulings is an assault to our civil liberties. A few of these cases are as follows. In the case of Shelby County versus Holder in 2013, the court struck down a portion of President Johnson's Voting Rights Act. In this landmark legislation, Johnson kept watch on the states that had been flagrant in disenfranchising citizens of color by forcing stringent veto laws, such as producing picture IDs and forcing persons of color to take a written test before they could exercise their right to vote. In 2010, in the famous case of Citizens United, the Supreme Court ruled that corporations are considered people. This case is about the strict limit put on corporations as to how much they can contribute to political candidates. Because of this decision, corporations can now contribute virtually unlimited sums to candidates, forcing them to become beholden to corporations that donate to them. This is how big business obtains control of politicians. In the case of Lewis v. Epic Systems Corp., the court delivered a blow to the rights of millions of private sector workers by ruling that workers may not band together to challenge violations of federal law committed by their employer. In other words, the right to protest has been made unconstitutional because of this case. It has been a historic right for workers to band together against their employers for legal infractions since the early 20th century. My question is this: how can the Supreme Court of the United States lean on the side of big business in lieu of the protection of rights of the American people? My answer: money and politics. Thanks for watching. I'm Rosalyn Tavanis.